Good afternoon. How's everybody doing? Good to be learning with you on a Friday, Yom Shishi. Let's light up the darkness. Who's in the house? Joe in the Inland Empire, Guy in Ohio, Gordo in Scotland, Paula in the Great Northwest, Shandor in the Bronx, Bella in Seattle, Ella checking in, Marjorie in Virginia, and Yitzhak in Minnesota. Welcome, everybody. Our daf today is Nun, page 50 here in Tractate Gittin, the 19th volume of the Talmud. We're working our way now through chapter 5. Continuing our discussion of Mishna number 1. Generally, we're in a section of this tractate where we're discussing enactments that the sages made, rabbinic decrees, for the betterment of the world. Now touching on monetary policy, monetary issues, and specifically that if somebody is owed money, either because he was damaged or his property was damaged, or because he lent money and the money is owed to him, or because there was a marriage contract and then the husband divorced the wife, or he died and now she's waiting for payment of the ketubah. So if the one who owes the money, or the estate in the case of a husband who died, if there's not cash on hand or movable assets, and we have to go to real property, appropriating real property, liquidating it, selling a piece of real property to pay off the debt, so the sages are making a distinction between superior quality property, intermediate quality, and inferior quality. And depending on the reason that the money is owed, the creditor or the party that was injured, or the divorced wife or the widow is going to be entitled to one of those types of properties depending on the situation: superior, intermediate, or inferior quality. So we pick this up at the very bottom of page 49b. Apropos a guarantor for a marriage contract, this issue of the guarantor came up at the end of yesterday's class. What is a guarantor? Okay, so, I'm contemplating lending some money to Jim, and Jim is not super trustworthy in my eyes. I'm not sure that he's going to pay me back the money. I'm not sure that he's going to have property that I can go seize if he doesn't pay back the money, or it's going to be a hassle to do that. So I tell Jim, you know what, I'm not going to lend you the money unless you bring somebody that I do have confidence in to guarantee the loan, right? Who's going to sign the promissory note as a guarantor. Now that sounds like if Jim doesn't pay me back the money, then I can go to the guarantor and have him pay me back the money. But as we'll see, there are different types of guarantors. There's the unconditional guarantor, which really means I can go to the guarantor to pay back the money. I may even be able to go to him first and then let the guarantor get the money out of the guy that I'm actually lending it to, in which the guarantor is signing his promissory note. And then there's the conditional guarantor, right? Where I have to go to the borrower first, and then if he can't pay or he doesn't have property, then I can go to the guarantor. And sometimes a guarantor is sort of getting involved and not really promising to step in and pay the money, as we'll see. Okay, so apropos a guarantor for a marriage contract, for a ketubah. So the Gemara notes, it was stated that everyone agrees, meaning all the sages who are having this debate, everyone agrees that a guarantor who signs a marriage contract does not thereby become responsible for the payment of the marriage contract from his own property. Maybe he's going to step in and help you, extract money from the estate, or in some way, but he's not pledging his own money to guarantee the ketubah. And everyone also agrees, now we're on 50A, everyone also agrees that an unconditional guarantor for the repayment of a creditor, right? Now we're talking about a lender-borrower situation. So an unconditional guarantor for the repayment of a creditor becomes responsible for payment of the borrower's debt, right? Even out of his own pocket. Now, what the sages disagree on is with regard to the following cases. A guarantor for the repayment of a creditor, meaning not an unconditional guarantor, but just a guarantor, plain guarantor, for the repayment of a creditor, and an unconditional guarantor for payment of a marriage contract. Now, there is one sage who says, although the borrower does not have property of his own at the time of the loan, at the time the loan is made, the guarantor becomes responsible for payment of the obligation. And there is one sage who says, if the obligated party has property of his own, then the guarantor becomes responsible. And if he does not have property of his own, then the guarantor does not become responsible. Now, this is odd, right? Because what we might have thought is, well, I'm lending money to this guy who seems like a bad risk to me. That's why I'm demanding a guarantor. And why does he seem like a bad risk to me? Because he doesn't have property of his own. So now you're going to tell me that the guarantor becomes obligated only if the borrower doesn't have property. Only if the borrower does have property of his own. That's when I kind of don't need a guarantor, right? I need a guarantor when the borrower doesn't have property. But according to this view, if the borrower doesn't have property, then the guarantor doesn't become obligated himself in the guarantee. So what's going on? So let's read this note from Rav Steinsaltz. The Rama writes that this does not mean, as the Rashbam explains in Tractate Baba Basra, that in a case where the borrower has property of his own, the guarantor is willing to pledge his property from the outset because he thinks that he will not actually have to repay the debt, right? Because the borrower has property. It is precisely in a case where the borrower has property that there is a concern that the guarantor did not completely accept the obligation upon himself because he thinks that the borrower will repay everything and the obligation will not apply to him at all. Rather, the reason the guarantor becomes responsible only if the borrower has property is as follows. When the borrower has property, and despite this, the creditor insists that he will not grant a loan unless the guarantor pledges himself to its repayment, this is a demonstration of honor to the guarantor, as he's being seen as responsible and of means, and his reputation is thereby enhanced. In exchange for this benefit, the guarantor commits himself and obligates him to repay the loan. And you can see why he might only do that if the borrower has some property of his own. Okay. And the halacha is, and the law is, in all of these cases, although the obligated party does not have property of his own, at the time he assumes the obligation, the guarantor becomes responsible for payment of that obligation. And this is so, except in the case of a guarantor for payment of a marriage contract. As in that case, even if the husband has property of his own when he gives the marriage contract, the guarantor does not become responsible for payment of the obligation. A guarantor of a ketubah, of a marriage contract, only becomes obligated if he writes himself in as an unconditional guarantor. Now, what is the reason for all this? The intention of the guarantor is performing a mitzvah of facilitating a marriage by encouraging the woman to consent to the marriage as a result of his involvement. But he does not truly intend to obligate himself. And furthermore, the woman does not lose anything in exchange for which the guarantor would accept responsibility, as the husband does not borrow money from the woman. Therefore, the sages instituted that the guarantor does not become responsible for payment of the marriage contract from his own property. He'll get involved. He'll help the borrower obtain the money, help the husband, obtain the money if he divorces the wife, or help the estate if the husband dies. But it's not that the guarantor intended to step in and pledge his own assets to guarantee the ketubah. So Ravina said, come in here a proof concerning the question of whether the Mishna's ruling that payment of a woman's marriage contract is collected from inferior quality land. So we had that in our discussion yesterday, that our Mishna said that a woman's ketubah, when she comes to claim it, is only paid from inferior quality land. And so we asked, is this both in the case of a divorce and in the case of a widow? And what's the distinction? If it's a divorce, okay, so then we're asking the husband to cough up the money that he owes for the ketubah. If she's a widow, then we're removing property from the estate, meaning we're removing it from the orphans. And so Mar Zutra said that a widow, that a divorced woman collects from intermediate quality property if there aren't movable assets to pay her ketubah, but a widow collects from inferior quality land, as is always the case when we are making a collection from orphans. Okay, so now we're going back to this, and we're trying to understand how this ties to the law of the guarantor. Right, so Ravina said, come in here a proof concerning the question of whether the Mishna's ruling that payment of a woman's marriage contract is collected from inferior quality land applies only when the woman collects from orphans, or if it applies even when she collects from her husband, widow versus divorce. So the proof is from the beginning of our ordinance. Why did the sages say that a woman's marriage contract is collected from inferior quality land? It is because more than a man wants to marry a woman wants to become married to a man. And if it enters your mind that this law applies only when the woman collects from orphans, then the reason given for this law should be that it is because they are orphans, not because a woman wants to become married. And this indicates that the Mishna's ruling applies even when she collects her marriage contract during her husband's lifetime, meaning a divorce, contrary to the opinion of Mar Zutra. And the Gemara affirms the refutation of the opinion of Mar Zutra is a conclusive refutation. Now, apropos a statement attributed to Mar Zutra, the son of Rav Nachman, the Gemara cites another law in his name on a similar topic. Mar Zutra, the son of Rav Nachman, said in the name of his father, Rav Nachman, if a promissory note is presented to orphans for repayment of a loan taken by their father, then even though an enhancement of the creditor's ability to collect is written on that promissory note, which enables the creditor to collect from superior value land, nevertheless, the creditor can collect only from inferior quality land. So this shows you how extensive the protection of orphans is, that even if the father, when he borrowed money and gave a promissory note to the lender, and the lender insisted that, well, if I have to come and seize part of your real property in order to satisfy this loan, then I need to be able to seize your superior quality land, not your inferior quality land. Nevertheless, even though that's contained in the promissory note, if the father died without repaying the loan and now the creditor comes to make a claim on the estate, even though his promissory note says he can seize from superior quality land, now that the estate belongs to the orphans, he can only take from inferior quality land. Now Abaye said, no, that this is the case, as the law governing a creditor is that he collects from intermediate quality land. But from orphans, he collects only from inferior quality land. If one cannot collect even from intermediate quality land of orphans, all the more so one cannot collect from their superior quality land. Rava said to Abaye, how can these two cases be compared? By Torah law, the halacha governing a creditor is that he collects from inferior quality land, in accordance with the opinion of Ula. As Ula says, by Torah law, a creditor collects from inferior quality land. Now, we've established in our Mishnah that a creditor seeking repayment of a debt collects from intermediate quality land. But that's by rabbinic decree. By Torah law, a creditor only collects from inferior quality land. This is what Ula is saying. And how does he know that? As it is stated, Deuteronomy 24:11, you shall stand outside, and the man to whom you have lent shall bring forth the pledge out to you. Right? So this is when you lend to somebody, you're not going to embarrass them when you're hounding them to pay back the loan. In fact, you stay outside the house and let him bring out the pledge. Right? Now, the pledge is where somebody is so poor that he pledges his garment, right? Or his pillow. And you're not going to, and you as the lender, can't hold on to that pledge, which should leave the man naked or without a pillow to sleep on at night. So, he might have to give you the pledge when he's not using it, and then you have to give it back to him when he needs it. But in any case, since the Torah says you shall stand outside and the man to whom you have lent shall bring forth the pledge out to you, so the Gemara says in the name of Ula, what would a man ordinarily take out of his house as a pledge? The least valuable of his vessels. And this demonstrates that the creditor is entitled only to the least valuable of the debtor's vessels, of his property. Similarly, when he collects from land, he collects only from inferior quality land. And for what reason did the sages enact, right? It's a rabbinic decree. For what reason did the sages enact that a creditor collects from intermediate quality land so as not to lock the door before potential borrowers, i.e., so that people do not refrain from extending loans? The sages enhanced the power of the lender so that poor people could find loans, right? If lenders were only going to be able to collect from inferior quality loans, from inferior quality land, then the credit market would, shrink. And with regard to orphans, the sages left the law as it is stated in the Torah, right? They're more protective of the orphans, but all they really had to do was leave the law as is, since the Torah mandates that creditors collect only from inferior quality land. The sages said, okay, generally creditors can actually collect from intermediate quality land, but not creditors who are coming after an estate that is passed to the orphans. But here, a stipulation enhancing the creditor's ability to collect was included in the promissory note. Now we're talking about this case where when the father borrowed money, he wrote in the promissory note that the lender could collect from his superior quality land. Therefore, since by Torah law, the halacha, the law governing the creditor, is that he collects from superior quality land, since that was written in his promissory note, as stipulated in the loan agreement, then he should also collect from superior quality land, even when collecting the debt from orphans. That's the question, should he? So the Gemara asks, and according to this explanation of Rava, there is a difficulty. Didn't the sage Avram Chozah teach a baraisa that states a father's debt can be collected from the property of the orphans only from inferior quality land? And the Gemara infers, and this ruling applies even if the property is collected for payment to injured parties who normally collect from superior quality land. But isn't it true that by Torah law, the halakha governing injured parties is that they collect from superior quality land? And this indicates that even when by Torah law collection should be from superior quality land, the sages instituted that one may collect from orphans only inferior quality land. So the Gemara answers, with what case are we dealing here in the baraisa taught by Avram Chozah? We are dealing with a case where superior quality land of the injured party is equal in quality to inferior quality land possessed by the one who caused the damage. In this case, the orphans. And the one who caused the damage also has land of superior quality. And the baraisa is taught in accordance with the opinion of Rabbi Yishmael, who says, right, we learned this a few days ago, By Torah law, we appraise the property of the injured party, and therefore the one who caused the damage can pay with his fields that are equal in quality to the superior quality land owned by the one who was injured. And so if the lowest value property of the injuring party is equal in value to the highest value property of the injured party, then according to Rabbi Yishmael, the one who caused the injury can pay using his lowest quality land. But remember, Rabbi Akiva disagreed with that, and the majority followed Rabbi Akiva that, as for the betterment of the world, one who causes injury has to, if he doesn't have movable assets to fund the damages, then he has to use his superior quality land to pay the damages, even if that land is of a far greater quality than the best quality land of the one who was injured. Right, by Torah, and this is in accordance with the opinion of Rabbi Yishmael, who says, by Torah law we appraise what I just read, and for the betterment of the world, the sages instituted that we appraise the property of the one who caused the damage, and he pays with his superior quality land. But with regard to orphans, the sages left the law as it is stated in the Torah. They pay from their inferior quality land that is equal in quality to superior quality land belonging to the injured party. By contrast, a creditor who holds a promissory note stipulating that the debt can be collected from superior quality land can collect superior quality land even from orphans because this is stipulated in the loan agreement. Does that work? So the Gemara asks, is that so? But didn't Rabbi Eliezer Nayota teach a baraisa that states a father's debt can be collected from the property of orphans only from inferior quality land, even if it is superior quality land? And the Gemara asks, what is the meaning of can only collect from inferior quality land, even if it is superior quality land? What does this mean? Is it not the following? Although superior quality land is written in the promissory note, the debt can be collected from the orphans only from inferior quality land. But the Gemara says, no, that is not what the meaning is in this situation. Orphans can repay the debt even from strips of superior quality land that, due to their location, these strips of superior quality land, cannot be cultivated or guarded, and that consequently have a lower market value than inferior quality land, as in the statement of Rava, which we're about to read. Right, so you can see that what makes land superior quality. One answer is, well, the soil is very fecund and it will, grow crops well. But you can adjust that value if, where these strips of land are, they're narrow, they're difficult to cultivate, they're difficult to guard, they're not accessible. There's other issues besides the soil quality. Now, Rava says, if one damaged inferior quality land, the injured party collects from superior quality land. The one who caused damage is penalized and made to pay from land of much higher quality than what he damaged. If he damaged strips of superior quality land that cannot be cultivated, the injured party collects from intermediate quality land, as the land that was damaged is inferior in value even to inferior quality land, and therefore it suffices if compensation is paid from intermediate quality land. And why did Rabbi Eliezer Nayota teach that orphans may pay their father's debt from land of the lowest quality? With regard to orphans, the sages left the halacha as it is written in the Torah, that a creditor collects from inferior quality land. Now the Mishna teaches, if one who owed money died and his children inherited his property, the father's debt can be collected from the property of the orphans only from inferior quality land. Now, Rav Achadevoy Bar Ami raised a dilemma with regard to the meaning of this statement. Do the orphans of which they spoke refer specifically to minors or even to adults? And the Gemara explains the two sides of the dilemma. Is this an ordinance that the sages instituted for the benefit of the orphans, in which case it may be argued that the sages instituted it for minors, but they did not institute it for adults. Or perhaps the reason is different. The reason that a creditor collects from intermediate quality land is so that the door not be locked before potential borrowers. And here, this is not a concern, since it does not enter the mind of the creditor that he should not lend money, as perhaps the borrower will die and his property will fall to the orphans. That's an unusual occurrence. As only if he were to consider this possibility would it be that this would lock the door before potential borrowers. Consequently, the ordinance that a creditor collects from intermediate quality land was instituted only in the standard case where the creditor collects from the debtor himself, but not where he collects from the heirs. Therefore, the ordinance that a debt can be collected from the property of orphans only from inferior quality land should apply also to adult orphans. And the Gemara answers, coming here what Abaye the elder taught, with regard to the orphans of which the sages spoke, the phrase is referring to adults. And needless to say, it is referring also to minors. So we had this question, somebody asked it a couple days ago. When they're talking about protecting orphans, does this only apply to minors? There's the answer. No. Even if they're adults, they are protected. But, wait, the Gemara rejects this proof. But perhaps this statement applies only to the matter of an oath. One who collects a debt from property left by the debtor to his heirs always takes an oath, even if he produces a promissory note. And this law applies even if the heirs are adults. And this is because even an adult son is considered like a minor with regard to his father's financial matters, since he does not know the details of his father's business dealings, and it is possible that his father had actually repaid the debt before dying. This is what I mentioned the other day, right? We treat him like an adult because he doesn't have knowledge of his father's affairs, and he doesn't know how many debts are going to come in or what happened. He doesn't have the full picture. But with regard to collecting the debt from inferior quality land, that aspect of the law applies only to minors. And the Gemara concludes, and the halacha is, with regard to the orphans of which the sages spoke, the phrase is referring to adults, and needless to say, it is referring also to minors, whether with regard to the halacha that a debt can be collected from the property of orphans only with an oath, or whether with regard to the halacha that a debt can be collected from the property of orphans only from inferior quality land. Orphans are orphans, and they are protected in this sense, whether with respect to the law of the oath or the law of collecting from inferior quality land. And by the way, an orphan under Jewish law is somebody who has lost one parent or more. Okay, now, the Mishna teaches payment of a debt or other obligation is now they don't but in terms of the law of inheritance, they're talking about the father, right? So but the point is that even though their mother might still be alive, they are considered orphans, and even if they are adults and their mom is still alive, they're considered orphans for this law. Now we are on 50b. The Mishnah teaches payment of a debt or other obligation is not collected from liened property that has been sold to a third party when the debtor still has unsold property, even when this unsold property is inferior quality land. Now, that's kind of a tough break for the one who has the lien, right? Because he said, okay, I'm going to lend you $1,000. And I need to have assurances that it's going to be paid back to me. So I'm lending to Jim, and Jim says, okay, you can have a lien on this field of mine. If I don't pay you back the $1,000, you can seize that field. Okay, then I lend you the money. So I lent him the money. Some time passes. And when I come back and I say, Jim, pay me out the money. Sorry, I don't have the money. Okay, then I'm taking the field. Oh, actually, I sold that field. Oh, you sold that field, but I had a lien on that field, right? So now if Jim has some kinds of other assets, maybe some other field, even though its land quality is lower than the one that I had a lien on, The sages would prefer that I go to this other property of Jim's and maybe take more of it in order to satisfy the debt, rather than we have to go find that third party who bought Jim's field that had a lien on it. And I say, hey, I had a lien on that field. He was not right to sell it to you. I'm going to seize that field now, and you guys can figure it out between you. I had a lien on that field. But the sages said, rather than undo, purchases and sales in order to satisfy a lien, if the borrower has other property that has not been sold, then we're going to direct the creditor to that property. Now, Rav Achadavoy Bar Ami raised a dilemma. What is the law with regard to liened property that the debtor gave to another person as a gift? Right? Okay, so if Jim sold that field, but he possesses other fields, so even though I want that field, they're going to send me to go to his other unsold property. What if Jim didn't sell that field, but he gave it to someone else as a gift? Does that change the situation? Can I then go seize it because, hey, that guy didn't put up any money? It's not like he's out the money. He's not going to have to deal with Jim for the money. He just received it as a gift. And Jim had no right to give that field away as a gift because I had a lien on it and Jim had an outstanding loan. Is the law that the debt is not collected from lien property that has been given as a gift to a third party when the debtor still has other property? And the Gemara presents the two sides of this dilemma. Is the halacha that payment is not collected from lien property that has been sold an ordinance that the sages instituted due to the loss of the buyers who would lose the money that they had paid for the property, but in the case of a gift where there is no issue of loss to the buyers, i.e. the recipients of the gift, as the recipients paid nothing for the property, maybe that halacha would not apply. Or perhaps the halacha applies to a gift as well, as were it not for the same benefit that the donor derives from the recipient, he would not have given him the gift. And therefore, this loss to the recipient is considered to be like the loss to buyers, and payment of the debt is not collected from the recipient of the gift when the debtor still has other property that the creditor could seize. Right? Are we going to treat the recipient of the gift like a buyer or not? And what's interesting is one reason to treat him like a buyer is, well, why did he receive that gift? I mean, to receive real property as a gift seems unusual. It must be that he did, provide some kind of a benefit to the giver of the gift, right? Whether it was, just having that relationship together or, because, like he's rewarding the recipient of the gift for some other service that person provided at another time. And so there is some kind of a quid pro quo, and we should treat him like a buyer. Anyway, those are the two sides of the question. Now let's go for the answer. Now, Mar Kashisha, the son of Rav Chisda, said to Rav Ashi, come in here what was taught in a Baraisa in the Tosefta, Baba Basra 9:6. If a person on his deathbed said, give 200 dinars to so-and-so, and 300 to so-and-so, and 400 to so-and-so. In this case, one does not say that whoever appears first in the deed acquires his money first. In other words, somebody on his deathbed says, right, give 200 dinars to Jim, give 300 dinars to Tom, give 400 dinars to Bill, right? Then is that an order of operations, or is that simply the statements that were made as he remembered them? In other words, does the one who was mentioned first have priority over the other ones in case there aren't enough assets? That's the question that is being asked here, and we'll see how that eventually comes back around to help us answer the question, is the recipient of a gift treated like the buyer of a field when that field has been mortgaged? Okay, so the one on his deathbed who just says, give 200 dinars to Tom and 300 to Jim and 400 to Bill, in this case, one does not say that whoever appears first in the deed acquires the money first. In other words, one does not have priority over the others. Therefore, if a promissory note emerged against the one who gave the gifts, right? Somebody on his deathbed said, give this money. But then later a promissory note came forward and said, you couldn't give away those money as deathbed gifts. You owe me the money, the creditor would say. So if a promissory note emerged against the one who gave the gifts, and it becomes clear that the money given was pledged to a creditor, then the creditor collects from all of the recipients of those deathbed gifts. But if the person on his deathbed said, give 200 dinars to Tom, and after him, give 300 dinars to Jim, and after him, give 400 dinars to Bill, now the person on his deathbed has created an order of priority, an order of operations, so that if a promissory note comes forward later and says that money shouldn't have been given away, and let's say that the money that was owed was 400 dinars, right? Or let's say it's 500 dinars. So can he go after all of these people equally? No, he has to go to the one that was last in line, take his 400. Then he goes to the one that was second in line to get his remaining 100. And that's the order of, seizing those assets. So therefore, if a promissory note emerged against him, the creditor first collects from the last one of the recipients, right? Last in, first out, accounting principle. If he does not have enough money to repay the debt, he collects from the previous person. And if that one does not have enough money to repay the debt, then he collects from the person listed before the previous person. So the Gemara infers, and this is the law, even if the property given to the first recipient is intermediate quality land, and the property given to the last recipient is inferior quality land. Although the creditor is entitled to collect his debt from intermediate quality land, the creditor in this case collects from inferior quality land because he's forced to collect from the last person to receive his gift. And he does not collect from the intermediate quality land given to the first recipient. So conclude from the Baraisa that the sage has also instituted this ordinance in the case of a gift, and that payment of a debt is not collected from lien property that has been given as a gift to a third party when the debtor still has property that has not been sold or given away as a gift. And the reason is that the second gift is considered to be unsold property in relation to the first gift, because when the first gift was given, the second gift was still in the donor's possession. So can we apply this line of thinking to our original case of the creditor who had a lien on a field that was sold, and the sages said you have to go to get the debtor's unsold property before you can go to the liened field. And then we ask, well, what about if that field was not sold but was given as a gift? Is it the same result? So according to this proof that was brought from the case of the sequenced gifts from the deathbed, it would seem that the gift of a field would be treated just like the purchase of a field. But the Gemara rejects this proof. With what are we dealing here? We are not dealing here with a person on his deathbed who is distributing monetary gifts, but rather with a debtor who is dividing his money between the various creditors. So the Gemara raises an objection, but didn't the person on his deathbed say, give the money to so-and-so? A formulation that indicates he is granting a gift. And the Gemara answers that what this means is, give this money as payment for my debt. The one on his deathbed wasn't issuing instructions about gifts. He was issuing instructions about which of his creditors should be paid first. So the Gemara asks, if so, why should the recovery of the debts depend upon the wording of the debtor's instructions? But let us see whose promissory note was written first. What difference does it make what this borrower says on his deathbed about which of his creditors should be paid first? We should just look at the promissory notes that are being presented, and the one which is earlier gets paid first. And the Gemara answers, we are dealing with a case where there is no promissory note. For example, where the creditors lost their promissory notes. So the Gemara raises an objection. But didn't it say in the Baraisa, whoever appears first in the deed, right, in the written instrument? And this indicates that there is in fact a written instrument. And the Gemara answers, the reference here is not to the promissory notes, but to the testamentary deed drawn by the person on his deathbed. So, if the person on his deathbed is giving deathbed instructions, this is a testamentary deed. Maybe somebody's writing it down as he says this. If even so there, he's not making gifts, but he's saying which of his creditors to pay back first. And this is in the case where the creditors don't have promissory notes to present, but the borrower is acknowledging that he owes this money. And since they don't know what order their loans were made in, he's saying, well, this is the order you should pay them back in. And if you wish, say, the Baraisa is referring also to a case of a gift. And even if the Mishnah's ordinance does not apply to lien property that has been given away as a gift, the law that the creditor collects from the last recipient is not difficult. As what is the meaning of the words he collects from the last recipient? This means that it is only the last recipient who really loses, as the creditor can collect from intermediate quality land wherever it is, even if it is in the possession of the first recipient. But after the creditor collects what is due him, the recipients of the gifts distribute the remaining property in accordance with the order set down in the donor's testament. Therefore, it will always be the last recipient who loses and no one else. And if you wish, say, the Baraisa is referring to a case where all of the properties are of equal quality. There is no reason to collect specifically from the first recipient because he has intermediate quality land, as opposed to the last recipient who does not. In such a case, the debt is collected from the last recipient. Therefore, there is no proof from here that the Mishnah's ordinance about liened property would apply in the case that it was given away as a gift, the same as it would for a buyer. We haven't made a proof about this yet. We don't know what the outcome is. New subject. The Mishnah teaches the court does not appropriate liened property that has been sold to a third party for the consumption of produce. Now we're going back to our Mishnah number 1 here in chapter 5, but we're discussing a new paragraph in it that we haven't discussed before. Right? So the Mishnah said that the court does not appropriate liened property that has been sold to a third party for the consumption of produce, right? So, I lent Jim money. I lent him $1,000. I have a lien on his field in case he doesn't pay me back. He doesn't sell the field outright, but he sells the rights to the produce. Does that change my ability to come in and seize the field? The court does not appropriate lien property that has been sold to a third party for the consumption of produce. This would seem to indicate that selling the right to the produce is like selling the thing itself, because where I have a lien on that field, even though it was only sold for the produce, it appears that the Mishnah is saying that when I want to collect property to pay off the loan that Jim is not paying me back, I should go to his other unsold property for that collection before I go to the liened field because he sold the rights to its produce. So the Gemara explains, Rav Steinsaltz explains, if one appropriated a field and sold it, we're going to a different example. If one appropriated a field and sold it, and the buyer worked the land, improved it, and grew produce on it, then the owner came back and took back his field together with the produce, the buyer cannot collect the value of the produce from property that the robber sold to another person. Okay, so it's a totally new case. We are going back to the Mishnah. We're not talking about a lien in the same way. We're talking about something else. If, imagine somebody says, hey, you want to buy the Brooklyn Bridge? I can sell it to you, and here's the deed of the Brooklyn Bridge, right? Now, we know this is, obviously a scam that only a fool would fall for. But somebody can do the same kind of scam in a much more sophisticated way. So what happened here is that the buyer thought that he was buying a field from the owner, but actually he was buying it from a scammer. The scammer pretended to be the owner, took money for the field, and then disappeared. So now the guy who bought the field, he thought, starts working the land, and he improves the land. He makes the land more valuable. Then the real owner comes back. Maybe he was away on an extended trip, and that's what allowed the scammer to pretend to own the land and sell it. But now the real owner comes back. He says, I'm taking my field back. Now the one who bought it from a scammer, maybe he didn't do his due diligence, and that's why he's getting penalized. But the one who, thought he bought the land and invested in it and worked it and improved the land, does he get something back? I mean, the owners whose land has now been improved, right, through no work or investment of his, but the fact that a scammer sold it, why should he benefit from that improvement of the land? Right, so again, if one appropriated a field, right, so the robber appropriates the field and sells it, and then the buyer works the land, improves it, and grows produce on it. And then the owner comes back and takes his field back, together with the produce that's on it. So the buyer cannot collect the value of the produce from the property that the robber sold to another person. What do you mean? Now I'm confused. Did the robber sell it twice? The Gemara asks, what is the reason for this? Ula says that Reish Lakish says this is because the produce is not written in the deed of sale. The obligation of a seller to reimburse the buyer if the field he sells him is repossessed by a prior owner or creditor is dependent upon the obligation recorded in the deed of sale. His obligation of reimbursement with regard to the produce is therefore treated like a loan by oral agreement, which is not a matter of public knowledge, and those who subsequently purchase land from the robber are not obligated to pay for debt incurred by a loan by oral agreement, as they had no way to know about it at the time of their purchase. Right? So it's almost like the robber sold the land to somebody who's a total victim of a crime, right? And then the original owner also sells the land, which is a legitimate sale. So now you've got two buyers. One is a real buyer, one is a buyer who got screwed. And now we're sort of working out what is going to be, what they're going to be entitled to, right? But the legitimate buyer doesn't have to worry about the scammed buyer because that's not his problem. Rabbi Abba said to Ula, but isn't the sustenance of a man's wife and daughters considered as if it were written, as even if it is not explicitly recorded in the marriage contract, it is one of the fixed stipulations of a marriage contract that are imposed by the court. It is known that a man is obligated to provide the sustenance of his wife and daughters, and yet the Mishnah teaches payment for the sustenance of a man's wife and daughters cannot be collected from the husband's liened property. And Ula said to him, there, with regard to sustenance of a man's wife and daughters, the sages instituted it like this from the outset. It is considered as if it was written with regard to unsold property, that it is still in the man's possession, so that sustenance can be collected from such property. But it is not considered as if it were written with regard to lien property that has been sold to another party. So many laws just got brought into this discussion that I'm personally having a little bit of trouble keeping it straight. So maybe it will help us to read where the law ended up in this discussion and Rav Steinsaltz's notes. Okay, here's where the halacha ended. The sages instituted that one cannot recover the payment for the consumption of produce and enhanced value of land from the liened property of the one who stole the land and sold it to him. Nor can payment for the sustenance of a man's wife and his daughters be collected from the husband's liened property. In both cases, this is because these obligations have no fixed amount. This is the opinion of Rambam, who rules in accordance with the view of Rabbi Hanina. However, the Tur, based on the Rif and the Rosh, explains that the reason is that these obligations are not written. And this is in accordance with the opinions of Ula, Reish Lakish, and Rabbi Yochanan. Let's just read a little bit more of this note. Rashi explains that the words, it is not written, should not be taken literally to mean that this was not written in the deed of sale. According to him, even if it is stated explicitly in the deed that the lien also applies to enhancements, produce, and the like, it would still be considered as if they were not written. According to Rashi, it is not the lack of writing that is critical here, but rather the degree to which the matter is publicized. The matter of land being sold is publicized, but a condition written in the bill of sale concerning produce that has yet to grow does not generate publicity, and a matter that does not become public knowledge cannot obligate the buyers. Tosafos explained that according to Rashi, anything that does not yet exist and about which there is uncertainty that it will ever exist is considered to be neither written nor publicized. Enhancements in produce fall into this category, and the Ramah argues that if the matter is written explicitly according to Ula, they can collect from property the robbers sold to others, and this is because anything written in the deed becomes publicized and everyone takes it into consideration. Okay. I'm almost done for today. If you have questions or comments, please put them in. And similarly, Rabbi Asi says that Rabbi Yochanan says, with regard to the Mishnah, why can't the payment for the consumption of produce be collected from property that the robber sold to another person? It is because the produce is not written in the purchaser's deed of sale. Rabbi Zera said to Rav Asi, but isn't the sustenance of a man's wife and daughters considered as if it were written in the marriage contract? And yet the Mishnah teaches payment for the sustenance of a man's wife and daughters cannot be collected from the husband's liened property. And Rav Asi said to him, the sages instituted it like this from the outset. Sustenance is considered as if it were written with regard to unsold property that is still in the man's possession, so that the sustenance can be collected from such property. But it is not considered as if it were written with regard to lien property that has been sold to another party. This concludes a discussion of one reason for the law in the Mishnah. Rabbi Hanina says that it is for a different reason that payment for the consumption of produce cannot be recovered from property that the robbers sold to another person. It is because the produce is not of a fixed amount, i.e., it could not be known at the outset how much produce would grow on the field or what its value would be, and the sages instituted that any obligation that is not of a fixed amount cannot be collected from property sold to another person, because the purchaser of the liened property cannot assess the risk he is assuming of having another person come to collect compensation from that property for a loss that he has suffered. Not easy. That's what we've got for today. Let's see if there are any comments or questions that I can answer. On Gittin, page 50, Leo Doron. Regarding the ruling about a scammer selling land. I'm not sure I understand. So Leo says, not true. He has maintained the land all this time for the scammer to be able... He has maintained the land all this time for the scammer to be able to scam. It is up to the owner's discretion to compensate the scammed fella, should he find improvements useful, and of course if he wants to. It is not the owner's responsibility. Furthermore, the owner can claim he was doing a shnat shmita and the buyer messed up. Okay. Bill, by way of a couple of examples about the way this particular scam can happen, firstly, a famous con artist, Victor Lustig, managed to con people into thinking he was able to sell them the Eiffel Tower for scrap metal, twice. And second, I, myself, meaning Bill, got taken for exactly this ride when I was apartment hunting at one point. Fortunately, I had a good credit union which declared that since the deal was fake, they could just reverse the transaction, so the scammer got nothing for their troubles. Okay. And Joseph, did they have some sort of law to determine how to value these kinds of land, like a blue book type of thing? Yeah, I mean, that question we had yesterday, I think Sharon asked it, and the answer, I think, is either the judges are able to make land appraisements or they would bring in an expert. Beyond that, I don't know. So I'm still a little bit confused, right? And so exactly who is going to be able to get what, right? We have an original owner who didn't know that his land was being sold by a scammer. And then we have a buyer of the land who thought that he bought the land and that it was his to use, and then he invested in it, improvement, and grew produce there. Then the owner comes back, and either the owner wants to take the produce, and then what happens to the buyer? The guy who thought he was the buyer, or the owner then turns around and he sells the property, and now you have an actual legitimate buyer. And what is going to be the relationship of the one who, got taken for a ride by the scammer? Who can he go after? I mean, certainly he can go after the scammer. Can he go after the innocent owner? It appears not. And then where there was a lien written into the deed, that seems to complicate things a little more. And basically where I'm at right now is I'm hoping I'll understand this better when we read tomorrow's stuff. That's what I've got for us today. And with God's help, we'll be together again tomorrow night after a late Shabbos. But tomorrow's daf is not overly long. So we've got that to look forward to late on a Saturday night.